1 2 test 1 2 test 1 2 test 1 2 test test 1 2 test. Test 1 2
All right. Yeah. Yeah. That's a good place. Yeah, it goes to this room only. And that's the problem. You have that on too. Yeah. I didn't want to leave that on too long. I was just checking to see if Peter was on. No, he's not on yet. We have to wait for Peter. Well, we can just leave it on. It's okay. It doesn't. All right.
Hello?
Peter, you on?
I am. Can you hear me?
Yeah, excellent. We needed you for a quorum. So
Gotcha. Oh, I am here. Took a little bit more talent than I had initially, but I think we're here.
Okay, excellent. Well said. With that, I'll call the meeting to order. First order of business is the Pledge of Allegiance. So good. Pledge of allegiance to the flag of
The United States of America.
to the republic which stands one nation under God, indivisible, with liberty and justice for all. Doreen, would you call the roll?
Richard Zookman,
Here.
Joe Doherty,
Here.
Michelle Stevenson. Here. Peter Freilinger.
Here.
Before we start, I just wanted to go over the general rules of the meetings that we have here. for the Zoning Board of Appeals. We have an agenda tonight. We'll go down through the agenda in the order in which the items appear. For any of the items where we have to make a decision, the process that we will use is that we will hear first from the applicant or the petitioner or the appellant, depending upon the case. That person will make his or her case before the board. We will ask questions. Once that process is done, we'll open that part of the meeting to public hearing on that particular application or appeal. People at that time from the public, either here or if they're online, can make comments. Once, excuse me, once that is done, we'll close the public hearing, and then the board will deliberate on the evidence it has before it and reach a decision. Okay. All of the information that that we will rely upon is in the public record. So every member of the public has access to it. If for some reason you don't have information that is in the public record, it's available on the website. But if something comes up tonight and you don't have access to it, please let us know and we'll figure out a way to make sure that you have it. The meetings are all recorded. Everything is in public. It's full disclosure. So if any of you over the course of the evening have any questions about it during the public hearing process, please interrupt and stop us and let us know what you want to ask. Okay. The first item on the agenda is the approval of the minutes for the April 8th, 2006 meeting that we had. I'm going to have a motion for that.
Motion to approve.
Second.
A second.
Okay, thank you. Any questions or comments on them? All right, hearing none, all in favor? Okay. Peter, are you still on? Did you vote or raise your hand?
I am. I'm having a little bit. Can you see me?
No.
Gotcha. I can see you, but I seem to be showing up as just Peter Freilinger. I can hear you. I did vote aye on the motion.
All right, excellent. I just make sure you're still there with us. Okay. The first item that we have on the agenda this evening is the written decision for appeal number 2794 for 23 Schooner Road. That was provided to all of the members as part of the packet. Before we vote on the findings, are there any questions or concerns about that finding and order? All right, hearing none, could I have a motion to approve it?
Motion to approve.
So,
I will
a
second that.
Thanks, Michelle. All those in favor, well, actually, Doreen, why don't you call the roll on that one?
Richard Silkman,
Yes.
Joe Doherty,
Yes.
Michelle Stevenson,
Yes.
and Peter Freilinger.
Yes. Sorry.
Good. Okay, so that is approved and we'll get that signed and everything will be taken care of on that item. The second item on the agenda is a written decision for appeal number 2795, a limited reduction of yard size residential appeal at 122 Winnick's Neck Road. Again, that information, that document was provided. I assume everybody had a chance to read it. Are there any questions or comments on it before we vote? Okay, hearing none. Doreen, would you call the roll on that one? Yes.
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 Okay. That one also is approved. The third item on the agenda, by the way, they don't all go this fast, and we'll come to the one that doesn't in a minute. The third item on the agenda is appeal number 2797. It's an administrative appeal by Cranberry Pines Homeowners Association regarding a project within the Homeowners Association. I'm not sure who is going to present the appeal, who's here today, but whoever is going to present the appeal, please come forward, state your name. We have to be at the microphone because this is recorded and it's on video. So anybody who wants to talk would have to come up to the microphone, but whoever is going to present that appeal, would he or she please step forward?
My name is Ryan Saucier. I'm here on behalf of the association as the association's president. I provided the information to the board in the packet that was submitted for the appeal. I understand that the board's not here to enforce private deed restrictions or resolve disputes between neighbors. We recognize that your role is to determine whether the code office properly interpreted and applied the town ordinances when issuing the permit. Our concern is that the project was approved, the project approved by the town was reviewed and discussed throughout the process as an accessory structure or guest house. We were under the impression that it was an ADU that was being applied for, not a guest house. But the permit ultimately issued was specifically for a single-family home. On February 23rd, 2026, the owner wrote to me looking for association approval for his permit. And he said in that letter, "We want to be very clear that our intent has never been to subdivide the property or pursue any commercial use. Our plan has simply been to build an additional structure in accessory to the main house so we can grow our family while remaining on the same lot." Based on that representation and the conversations that occurred between the owners, the association, it was my understanding that the town was reviewing an application for an accessory dwelling unit or an ADU, not a separate single-family residence. That distinction is very important because the association's governing documents do allow for a designed accessory dwelling unit, and the only reason I provided my letter of support for the project originally. It's also important for the board to understand that when I submitted that original letter of support, I did so under the impression that the application being reviewed was for an accessory dwelling unit. It was not until later that I became aware the permit application had originally been submitted as a multifamily dwelling and then later changed to a single-family home. Had I understood that a separate single-family residence with separate utilities and separate driveway was being proposed to the town, I would have never supported the application in the first place, and I don't believe the permit would have been approved. The permit that was ultimately approved specifically authorizes a single-family home. It doesn't say guest house or ADU, it says single-family home. The proposed structure is physically distant from the primary residence, designed in a manner capable of independent residential use, and does not appear subordinate in character or function to the existing home. Under both the spirit and intent of the zoning ordinance, accessory structures are intended to remain incidental and subordinate to the principal residence. In this case, we believe the town failed to adequately consider whether this proposal crosses the line from accessory structure into what is effectively a second dwelling on the lot. Excuse me. This is particularly significant because the subdivision governing documents clearly contemplate only one single-family home per lot. While we understand those restrictions are private matters, they are highly relevant to understanding the nature and intended use of the structure being proposed. The association did engage in good faith efforts to try and resolve the matter cooperatively, but unfortunately the issuance of the permit has accelerated the conflict and placed the community in a position where legal action may now be unavoidable if the permit is allowed to proceed. This appeal is not about preventing reasonable property improvements, nor is it about personal disagreement between neighbors. It is about whether the town properly applied its own ordinances to a structure that appears to function as a second dwelling rather than truly accessory use as it was described to the association. For those reasons, we respectfully ask the board to closely review the classification of this project, the interpretation applied by the code office, and whether the permit approval was consistent with the ordinance requirements governing accessory structures and dwelling units. Thank you for your time and your consideration. Do you have any questions? I'm sorry.
Mine.
Yeah.
Does anybody have any questions of Mr. Saucier?
Maybe in a minute.
Okay. Mr.
Actually-
Saucier, Peter, do you have any questions?
Richard, I do. I'm sorry. I keep trying to find the mute button on this, and I apologize to the appellant as well. It's unfair to you as well. I'm doing the best I can. In any event, so as I understand it, the subdivision and the parcel are located in the RF district. Is that correct?
I believe so.
In the RF district, I believe that multiple single-family dwellings are available subject to performance standards, mostly due to minimum square footage within the parcel. And this parcel is a 10-acre parcel, if I understand correctly.
That's correct.
In general, such parcels, absent any private contractual arrangements, a 10-acre parcel would allow at least 4, if not 5, single-family dwellings without a subdivision. So I'm wondering, where do you think the error is in approving a single-family dwelling? The ADU, whether it's an ADU or not, is almost irrelevant in this case, in my mind. A 10-acre parcel in the RF can and is designed to support multiple single-family dwellings. So I guess, where does the town get involved in this, given the town's designation of standards for the RF district?
So at the onset of the project, well, first of all, let me back up. The town doesn't necessarily have the obligation to enforce private covenants, and we understand that. It is in our governing documents, it states specifically only one single-family home allowed per lot, with accessory structures such as a guest house or garage allowed. I think the issue is I was led to believe that the application that was being submitted to the town was for an ADU, not for a guest house. Just because the Scarborough doesn't define guest house doesn't mean there isn't a definition for guest house. Guest house typically is a smaller than the dwelling itself, sometimes without a kitchen or a bathroom for an in-law or a guest to sleep in. So leading me to believe that there was an ADU application being filed, that is what I assume Scarborough was looking at. And to have a single family home being put on a lot where it's specifically not allowed, they would have never gotten the approval from the association or from me personally to the code enforcement officer, and the permit would not have been issued in the first place.
Well, I
I
understand
know
that.
this. I know this because once I reached out to code enforcement after I was made aware that this was a single family home, they did rescind the permit.
Well, I guess my point is that, yes, I understand, had you been aware or had you had a different understanding of the facts, you as and I think you're the HOA president, right? Or the
Correct.
HOA manager.
Correct. Yes.
Apologies if I have the title wrong. You would not have have effectively endorsed the proposal from the resident, and that would have gone to the code enforcement officer and probably would have nixed it on arrival. Nevertheless, the sequence is what it is, and the timing is what it is. It strikes me that the code enforcement officer, given the timing that he had available to him, or he or she had available to him, acted correctly. And now this just falls back on a civil action between you and the homeowner. It could have been stopped earlier, but for the sequence of events. The sequence of events, though, are what they are. We are at the point of where we are. I'm troubled to find, or I'm struggling to find where the CEO could have made a different determination, given our RF, the standards for the RF district, other than to allow the building of anything, whether it's an ADU or a second single family dwelling. Both are fully eligible under the RF district. Had he or she been aware that it was violating an HOA term, which they were not, then I could see that there might have been an administrative deficiency here. But given that they were not aware, they seem to have done the correct action under our ordinances, and now you're just left with a civil action. So help me understand where the CEO, the code enforcement officer, has to be preternaturally aware of contractual restrictions that are not brought to their attention as part of the process.
So the information was brought to their attention.
When?
And once they issued the permit,
Okay, that's my point.
yeah. And then
it
they rescinded the permit,
It was given.
which in our opinion was the correct thing to do based on the information that was provided to him that only an ADU would be allowed on the property. So an incorrect application was filled out for the purpose of building this.
Is the CEO
so.
responsible for an incorrect application?
I don't know, is he? That would be
The answer is no. And you've
if he's not responsible, that
you've
he
actually already
rescinded the
proven my
permit.
point. You've actually already proven my point. They approved the action with the information they had available. That information would have forced them to approve a second home to be built on the RF land, absent other information. And in fact, even given the information of the covenant restriction, they may have been in a position where they would have been felt forced to approve the permit subject to a agreement or subsequent discussion with the HOA. So I'm really struggling to understand how an administrative failure occurred here.
Can I interject and ask a question?
Sure.
What was it originally? Were they asking for this permit, like for a single family, or did they apply for an ADU? Because I don't think we have that. Do we have that?
Single family. They applied for a single family.
So they, they applied for a single family, permit was issued, then it was rescinded,
Correct.
is what you're saying.
Yes.
And then after review
don't-
of the discussion among the parties, my understanding is at that point, the code enforcement officer knew about the covenant, but then reissued the
Correct.
permit.
With no changes to
No
the permit.
changes to the
Once he
permit.
had all the information available, they still issued the permit.
Okay.
And we were, like I said, we were under the impression the application was for an ADU, not for a single family home.
What made you under the impression that it was for an ADU?
So prior to their purchase, I had conversations with another gentleman, phone conversations. He was a representative of the family. They continuously used the word guest house, accessory to the structure. It was in emails to me that there was going to be an accessory. So looking up on Scarborough's website, if you actually Google Scarborough guest house permit application, it brings you to the ADU page.
Yeah.
And so everything leads to the ADU. And that's what's allowed under our governing documents. So
My second question about this is that in your governing documents, is there anything that you as the HOA can do, impose fines, all those things? Like, why are you coming to us after the fact? Is there anything that you can do? Because I don't know. I have part of your stuff here, but
sure. I mean, at the end of the day, Maine condo law supersedes Scarborough ordinances. So if your permit were to be issued today, it's going to be up to the association to file suit if they were to continue with the process. I think the reason why almost every homeowner, I think, from the association is here is to try to prevent that. And I think the Scarborough Board of Appeals could prevent neighbors having to go to court over this. We've given them the opportunity to scale down, to make the house subordinate to the main house and keep the size. We've tried numerous different things to try to make this work, and nothing seems to help. So this is kind of a last-ditch effort to avoid having to go to court with our neighbors, which we really don't want to do. But going back to the permit, I think if it would have been an ADU permit that was filled out, we wouldn't be here right now, because it is allowed within our condominium documents. It is, the deed restrictions that are filed with the registry.
But you do acknowledge that the RF district allows for multiple single-family homes on a property of the sort owned by by your homeowner.
It seems to me that what we have here is perhaps either a misunderstanding or a disagreement among about definition. And I mean, the condo documents specify accessory dwelling. You know, we don't know what that accessory dwelling is. Certainly,
Scarborough defines accessory dwelling.
well, Scarborough doesn't define accessory dwelling in its zoning ordinance.
Scarborough does define accessory dwelling unit. I believe it's guest house that doesn't
Guest
have a
house.
definition.
Oh, there was guest house that didn't? Okay.
Yeah.
So it's guest house that doesn't have it, but it was a guest house that was referenced. And at some point, that decision has to be made as to whether or not what they're proposing violates your ordinance or your homeowners association agreement. And it may not violate Scarborough zoning ordinance, which may make the permit a valid permit. And we can't determine whether it violates your homeowners association agreement. We're not equipped to do that. So it may be that your course of going to court may be the only option available to you, given the constraints that we're operating under here. So I'm just, you may end up there.
Sure.
I assume that your homeowners association agreement doesn't have mandatory arbitration or mediation clauses to it for disagreements?
Maine state law does though.
Okay, so
It's-
that's, you're right, you're out of it, you're into Maine law at that point.
Yeah, I think, like I said earlier, Maine state law obviously supersedes any town ordinances. And it does back the association to enforce our governing documents. So regardless, I think of what Scarborough decides today, Maine law will back the association.
Well,
We're trying to avoid that. Yeah.
Richard, if
I'd like to, if I could
You're-
step aside and let some of the other owners,
I
they're,
think you have to open public comment
Okay.
for other people to
Sure.
speak, but I would like to say something where my thoughts are, is that I appreciate all of you coming out and really you all clearly are very passionate about this and it's where you live. If this was applied for as an accessory dwelling unit and it was approved for a single, I can see this moving forward, but I'm having a really hard time with the fact that, I mean, not saying this person, this company sounds like they kind of, deceived you a little bit with what they were trying to get approval for from you guys, and I'm sorry for that, but that's not anything we can do. But it sounds like, and we'll go through the facts more, that, what was approved and what was applied for are accurate.
I think the original permit might have said multifamily on it. I'm not sure if that is relevant or not. But I'm still fairly new within the association, 5 or so years. There are folks here that have been with the association much longer, might be able to give you more background or have a better understanding of how, it's worked in the past with our association. It's 30-something years old. And this is the first time something like this has come up for
Okay.
this small road association, so.
Sure. Peter, do you have any other questions?
I don't, but I do want to point out, I'm troubled by the fact that the appellant is asking us to find the code enforcement officer to have committed an error in order to avoid court. I think the courts are the right forum for adjudicating private disputes over contracts. There's nothing wrong with that. There's nothing that's not a bad thing. That's what that's what their intended use is. So I'm a little concerned that they'd rather hold a public official effectively publicly as being not correct or not competent in their decision, instead of simply using the mechanisms of state law as they were designed to be applied.
Well, if I may respond to that, sir.
Sure.
We're not saying that he was incompetent in his decision, that he made a mistake, but he was provided the language from our documents. And that is when the permit was rescinded. At that point, he had the information, actually he had it beforehand in my letter of approval. It does state the accessory. It does state that, what our condominium docs allow before the permit was actually issued. So the information on the documents was available to him before that. And so I'm not saying that he made a mistake in issuing the permit for the single family home. I'm saying he should have understood it. It should have been a application for an ADU, which Scarborough does define.
And again,
The incorrect application was filled out for the property.
I don't find the timing of the CEO's knowledge to support that story. On the one hand, and on the other hand, if we take that at face value, then what you're really angry about, or what really is the administrative failure here, is actually the rescinding of the initial permit. That permit never should have been rescinded, because building a single family residence on a 10-acre parcel on an RF district in an RF district is assuming all other conditions are met, and there are frontage requirements and all the rest. But assuming all of the requirements are met, the CEO is bound to approve a valid application for such a construction. So
He's
either
not
you're-
obligated to take deed restrictions into account before issuing
No,
a
no,
decision
that's
at all.
those are private contractual matters, sir. Those are private contractual matters. There's no way the CEO can be expected to uncover all private contractual matters regarding a given property. He or she can only deal with the facts of a given construction, given the zoning requirements of the town is set up. No.
Okay.
Is this from Scarborough?
Are you done now, or?
Can I have assistance from another member of the association?
Sure. Yeah, by all means.
So the
Before you do, could you state your name?
Mike Scammon, 4 Cranberry
Thank you,
Pines.
Mike. Yeah.
Well, that's loud. Okay. So I reviewed the initial permit application, and it has in the application the warranty deed, which points to and states that there are deed restrictions. And in the Scarborough zoning ordinance, there's a section that says conflict with other ordinances. Wherever the requirements of this ordinance are at variance with the requirements of any other lawfully adopted rules, regulations, ordinances, deed restrictions, or covenants, the most restrictive or that imposing the higher standards shall govern. And so in this case, my thought is, when that application points to the declaration of restrictions, that pulls that into the application, and they should have been considered. And if they were considered, then the points would have been: 1, there can only be 1 single-family dwelling per lot. 2, lots cannot be subdivided. And 3, the wording and the restrictions are that such other structures as may be accessory thereto, such as a garage or a guest house, are permitted. So that would make the guest house accessory to the primary residence, which is already there.
Again, I'm not arguing that point. I'm arguing the idea that the code enforcement officer has omniscience over all covenants, deed restrictions, etc. What the code enforcement officer has access to is, or are, the state and municipal requirements for a given property. Other restrictions, deed covenants, etc., need to be supplied to him or her. If they're not, then the CEO has no choice but to grant a permit to build, and then leave it upon the other parties who may be affected by a deed restriction or a covenant or whatever to enforce their rights in a civil court. I think you guys will succeed admirably in preventing the construction of another single family house on this property, given your HOA construct.
But given your,
I don't take it as excuse me, let me finish my point. I don't take it as a requirement or a point of administrative error that the CEO does not delve into every last I, T, and period in all associated documents, because that would make the CEO's job practically impossible. And I don't think that's the intent of what we say in our, in the ordinance that you cite.
So given the wording of the conflict with other ordinances, which is in our zoning ordinance, right, for the town, and if the application refers to deed restrictions, wouldn't it be prudent for the code enforcement officer to at least request a copy of those
Did
to
the,
make sure that they don't violate their own code?
No, because at what point does the CEO have to continue to ask and ask and ask? The CEO is not focused on on this specific application to the exclusion of all others. And they're allowed a presumption of information. They are allowed that.
We're gonna go around on this quite a bit. I mean, this is obviously the central issue.
Right.
And so why don't we just hold off on it? We'll discuss it.
I'll
when we
make
get
one
to-
other point, and then if it turns out that the town keeps the permit, approves the permit as a single-family residence, then you're in the dilemma of you've either violated the declaration of restrictions because it's one house only, can't be subdivided, or the town is by default defined a new term called guest house. And I don't think this is how the town wants to define a term that falls under the zoning ordinance. That's all.
I
That's my
wholly
point.
disagree. I wholly disagree. The only thing we're doing is saying this is now a private matter. This is no longer a matter for the town to be engaged in.
Okay. Let's see. We have the code enforcement officer here with us. Would you be,
Legal representative as well as.
okay,
So.
would you folks please stand up? That'd be helpful. We can ask a few questions of you.
Time to ask a couple questions.
You'll have time to speak at the public session, and you can respond to anything that they might say at that point.
Good evening, Mary Costigan with Bernstein Shore. So just to be clear, I'm not here tonight on behalf of the board. I'm here tonight on behalf of the CEO and staff. I did consult with them when this all came up. I'm just going to clarify the legal issue, and then I'll turn it over to the CEO to talk about the factual issues. What's just to kind of explain how this all works, right? So yes, there is an ordinance provision that talks about what's most restrictive. That is when we go and turn to a deed restriction, that is the unusual circumstance where there's a restriction, and so everyone has to turn in their deed to show right title or interest, right? So there could be something in that deed itself that's just so glaringly obvious and needs no interpretation at all on behalf of the code or the staff. The only law court case that did uphold a decision on the town who kind of made their decision based on an easement was that easement said like no cutting trees, and the application was for cutting trees. I mean, it was just that black and white and easy. What the code enforcement officer cannot do is interpret a private covenant. The code enforcement officer cannot interpret what guest house means, what accessory means. The definitions of accessory, of guest house, what have you, if they happen to be in the Scarborough ordinance, you don't take those and transpose them onto your private agreement. So the private agreement is the private agreement, and the CEO has zero authority to interpret that language. And that's what those covenants, it left the code enforcement officer in a position of having to make an interpretation, and that just simply cannot happen. So we then just are completely focused on what the ordinance allows, and the ordinance does allow a single family, and what guest house means, what accessory means under the covenants is up to you guys. It is not up to the code enforcement officer to decide that. And even if the town has a definition of guest house, it doesn't mean that that's exactly the same as the definition, because you don't have it's undefined, and you don't look to the ordinance to see what that's defined. You look to your own, how the document was created, and you know what you think the definition is, or a common definition, but that's when you kind of battle it out privately and not with the code enforcement officer.
Then why the flip-flop?
No, please, you'll have an opportunity to talk when they're done. Thank you.
Hello, Michael Demers, Code Enforcement Officer.
Could you just walk us through the process that you went through in terms of, in a little bit of the timeline to reach your decision through both the initial acceptance, rescission, and then final approval?
Sure. So initially received the application for a single-family home. And I do believe the original application said multifamily home, and I think the confusion there with the applicant was that there was going to be two full homes on the one lot. So the in reviewing the application, standard procedure, review the application, obviously, the deed, read the deed. I did notice the calling out of deed restrictions, and reached out to the applicant for clarity, requested documentation from the association in support of that. More so, the reasoning there was to potentially, well, get the matter cleared up right from the get-go. And if it wasn't going to be allowed with the HOA, that the applicant wouldn't have to pay the permit fees, associated with that permit. Did receive a letter from the HOA fully in support of the proposed structure. And it did actually say that they reviewed the plans and approve it. And so that's when I did issue the permit after, full review of other performance standards and that. I think the land was being prepared and some neighbors had concerns, and that's when the HOA reached out to me and expressed the concerns. And I did rescind the permit initially so that it would possibly give us some time to straighten things out between the two parties. After it became clear that there might not be a quick and easy method to, or path to conclusion, I reinstated the permit because as my initial original decision was that it is an allowed use in that district. So, and the path forward then is either a civil matter, which I put in my letter. Well, I don't know if I did a letter. Anyway, yeah, to the HOA, I expressed to them that a civil matter could be pursued, or if they think I was in error, to go, apply to ZBA, and that's where we are today.
During that process, did you try to interpret their homeowners association agreement in terms of what an accessory dwelling or a guest house would be?
So we do have a separate accessory dwelling unit application for the town of Scarborough, and that was never applied for. It was always a full second dwelling. And I think early on in the application process, I did clarify that with the applicant that this in fact is a single family home, right? So that was always on my desk. That was always the what the application
I
was
have a
for.
question. Do you
So-
recall in the letter that the HOA president wrote in favor of this project, did he at any point state, like, we're in favor of the accessory dwelling unit, guest house? Was it specific, or did it just say project? I don't think that we have that.
I believe it was more in general, the project, we're in favor of the project. It might have said guest house, and yeah, they were definitely in support of the project. They said they had reviewed the plans, so.
They said as described.
No, okay. Are there any other questions?
Yeah.
Sheila?
So was the HOA provided a copy of the application when you sent the letter and asked them, you said you sent a letter to them?
Yeah, it was email back and forth, and
Is that standard to do?
uh,
When you issue a permit to, and an HOA is involved, not when you issue a permit, because that's not what you're asking, is when you were asking for the
Yeah,
covenants?
I'm obvious. So the HOA sent a letter to code enforcement stating their support for the project.
it actually
Just to
came
go.
via the applicant. The applicant had.
The
received-
applicant gave
Yeah,
that.
yeah.
Okay, but the town wasn't involved in that discussion, or was it?
Not the applicant and the HOA discussion.
So the applicant and HOA, as far as you know, they had a discussion. Coming out of that discussion, you received an email or a letter, some communication stating that the HOA supported.
Correct.
Okay, thank you.
Peter, do you have any questions of the code enforcement officer?
Yeah, one question, when you mentioned that when it became apparent that there wasn't going to be a simple agreement, you reinstated the permit. How would you characterize then how you use the rescission of the permit as a tool in the process?
Sure. This was, once we received concerns from the HOA, I brought those concerns to the planning director. We had a brief discussion and thought maybe that would be the best move forward so that the applicant is aware that essentially this permit's on being rescinded so that they don't get into a lot of contract, excavation or foundations and stuff without us further reviewing, because we can rescind a permit for any reason within 30 days, I believe, so.
And this was within that 30-day window?
Oh, yes.
Okay. Okay, thank you.
Could I ask a question of the attorney? In terms of the process for the zoning board of appeals, if we make a decision one way or another, let's say that we turn down the appeal, does the appellant have the right at that point to go to the court with respect to our decision, independent of going to court with respect to the enforcing the HOA agreement
The appellant does have the right to file an appeal in court.
in
yes.
court? And that would be whether or not we turn it down, or the original applicant for the proposal could file it if we accept the appeal.
That is correct.
All right.
Yeah.
So there are two methods for them to get to court. One is through our decision, the other is through the enforcement of their own HOA agreement.
Correct.
Thank you. Peter, do you have any other questions of,
Not right now, no.
okay,
Oh, I think I have one more question.
Sure.
For the enforcement officer. When you issue permits and there's HOAs involved and you have asked for some of the documents, is it standard or typical for you to have any more communication with the HOA versus the person applying for the permit? Like, is that something that I'm trying to determine if that's something that's typically done and it wasn't done here, or
No,
Is-
this
is that done as a courtesy ever, or?
it's a courtesy. It really was, trying to see maybe a potential future dilemma and avoid it, was with, my request from the applicant to provide HOA support was just making them aware that this deed restriction does exist and they're aware of it.
Richard, I do have a question of the town's legal then.
yes.
If the CEO does as he indicated and performs a courtesy, recognizing that there may be a conflict or there may be sort of unanswered questions, does that now create an obligation on the town that didn't exist simply because they didn't extend the courtesy?
I'm not quite sure if I understand your question. Does it create an obligation on the town to do what?
To run it to earth, to basically say,
No, yeah, no. I mean, he doesn't have the authority to interpret their agreement. I think he was just kind of, like he said, you catch it within the 30 days, so everyone's on notice that there might be an issue. It's kind of a pause button to see if anything could be resolved. Also was a time to talk to legal counsel about it too, and see what was going on. But no, it does not create any type of obligation to dig deep, nor do they have the authority to do that.
indeed, his obligation remains to not interpret the private contract.
That is correct.
And thank you. Okay.
Anything else of the? Okay. What I'll now do is open the public hearing portion of this meeting. Anybody who would like to speak one way or another on the appeal is welcome to do so. And what I would ask is just in deference to everybody here, try to keep comments focused and to the point and try not to be too repetitive. I understand everybody has strong feelings about this. We appreciate that, but do your best. Okay, so. Oh, Peter, did you raise your hand or is that just showing up now?
Thank you for asking if it was an error, because I've been trying to figure out how to get on video all along here, so I've been pressing random buttons.
Okay.
I
All right,
might
we're good.
suggest that we limit the amount of the total volume of public comment. Again, I noticed a lot of people in the room, which I didn't see until I saw a pull away note, and we might, in partially in deference to other appellants who are here tonight, allow kind of restrict this to, I'm not sure, 20 minutes, 15 minutes, something that you might see fit, Richard.
Okay, sure. There's no particular order, so whoever wants to go first, sure, why don't you in the back, or you're all set, go ahead. You're close? You're good. What I would ask you to do is just introduce yourself and maybe give your name and address.
My name is Jason McFarland. I am a part of the association, vice president. Following what Michael came up here and said, I just wanted to read the email that Michael sent to the lot owners when he was taking the permit away. Because I feel like after I read this, you'll find a lot of, there's a lot of hypocrisy, and I think it'll bring up more questions for Peter, some of the things he was saying. So he says, "Hi Pete," which is the lot owner. "Following the issuance of the building permit for 12 Cranberry Pines, the Code Enforcement Office reviewed the proposal against the approved Cranberry Pines subdivision plan and the applicable limitations associated with that approval. Based on this review and in light of the subsequent information regarding the scope and scale of the proposed guest house, we determined that the project, as currently approved, may not be consistent with the parameters of the original subdivision approval or associated restrictions governing the lot. As a result, the town cannot allow the project to proceed under the currently issued permit without further clarification and/or modification. Accordingly, the building permit is hereby rescinded at this time, and no further work is authorized under that permit." I'm going to paraphrase the three things he asked to move forward. One was revise the proposal, one was obtain written agreement from the association, and the other was to pursue a subdivision plan. Then he goes on to say, "Please note that the town does not enforce private covenants. However, when subdivision approvals and recorded restrictions affect the scope of development, the town must ensure that permits are issued in a manner consistent with those approvals. Once these matters are resolved, we would be happy to continue to review of a revised or updated application." Neither of those things, not the three things or what he says at the end, ever happened. And then so it's hard for me to know who to believe. Like, does the town actually get involved? Because I have here many different ways that they do, but then I think Peter said they don't, the attorney said they don't. And then just one more thing, the attorney brought up someone brought up how cutting trees was a very clear thing. Our restrictions aren't very long. It clearly says one single family home, and they filled out a permit for one single family home. So I understand it's not the town's job to read through a whole set of condo docs, but it is as cut and dry as she referenced, in my opinion. And it could have been a very easy, no to the single family home.
Thank you very much. Appreciate that.
Could you
Yes,
who was that? That was helpful. Who was that?
I'm Jason McFarland, 9 Cranberry Pines, and Vice President of the association.
Jason, thank you very much. Appreciate it.
Yep, thank you.
Hi, I'm Kim Stauber. I'm a part owner of 12 Cranberry Pines, along with my husband and my mother-in-law. Prior to purchase, we saw the lot, we saw that there were deed restrictions, specifically saying that it did allow a guest house. We knew we wanted to grow our family and we want to do so next to our mother-in-law. We contacted the HOA. We specifically said, we understand that it allows guest house. We specifically said it would be a large guest house. The HOA president said, yes, it does allow this. He even said, yep, there's no definition in Maine specifying the diameters around guest house. We moved forward with the purchase of the property. We reached out to the HOA president. We said, we want to make sure we're in compliance with this. We're now learned we're expecting twins. And I only feel like that's relevant because in no way did we ever try to make it seem like we wanted to do an ADU, nor would that ever fit our needs. So we said we want to be in compliance. What would you need? The reply back was, can you just write a letter saying that you won't rent out the property? Yep, here's the letter. He wrote a letter back acknowledging that he had reviewed the plans, that they were in compliance, that they did not violate the HOA's rules. And he also stated that the HOA documents do not define specific characteristics of what constitutes a guest house. A lot of emails back and forth. I won't bore everyone with it. I think just the main sticking points are we never said ADU. We always were very specific about guest house and what our needs were for the guest house. And there was one other point I wanted to make. Yeah, and my husband. What am I missing?
Excuse me, I'm Pete Stauber. In the permit application, there is no guest house checkbox. So when you build a guest house, you still have to follow all of the same rules in terms of building up to code as a single family resident. So there is no guest house. And we know we don't want to do ADU. If we want to do an ADU, we would have put that in the checklist. We made it clear we wanted a guest house and yeah.
Oh, I remembered the last thing, sorry. Just in going back and forth with the town, it was said by the town of Scarborough that a single family residence can fit a guest house. So that's all. Thank you.
Husbands are so convenient for filibustering, isn't it?
I know.
Isn't-
Yeah. Thank you.
Thank you very much. Yes, ma'am.
My name is Laura Gordon. I am a resident of 7 Cranberry Pines. I guess one of the first questions that I have is the lady, the legal representative, she introduced herself so fast, I did not catch it. In what capacity are you representing the code enforcement or the actual town of Scarborough?
She, I believe, clarified that and said
And I didn't hear it. That's why I was asking you guys.
representing the code enforcement officer,
Okay.
not the town of Scarborough.
And my second question would be, is that
No.
something,
No, she's representing the town of Scarborough. She's not representing the zoning board.
The zoning
She's not
board,
our
yes,
attorney.
sorry.
She's representing the town, which the code enforcement officer is a part of.
so it's the code enforcement department that she's here representing this evening
And indirectly, therefore, the town of Scarborough.
and for the town of Scarborough? And my other question to you would be, is that something that is common at the stage of what we're doing tonight? You have somebody that comes in and represents that legally.
Yes, and far as I know, in all appeals before the board, where we're questioning a code enforcement officer, there's legal representation for that
Okay,
person.
great.
Yes.
My second question was that she stated that code enforcement does not have the capacity to interpret different guidelines and standards of HOAs. However, we've seen in the past hearings and also what was stated this evening that that is a common occurrence. And I would ask, what is the expectations of code enforcement to be able to interpret when they are in a position to have to make decisions on, you know, a lot of different things. So that was kind of confusing as far as what they can interpret and what they can't. So my question would be, I would like to know what the decision was that he interpreted that made him first take it back. So he interpreted something there that, you know, whether in what I perceived as him saying was he took it back to give us time to figure this out. So I guess there had to have been some type of interpretation on that. But my question is, and I apologize, I'm not familiar with the gentleman, Peter, who is not with us tonight, but is on the meeting with us. I guess my question, I have a question for you, sir. What did you mean when you stated you don't agree with the timeline of the HOA contacting the town? You immediately said and interrupted our president, stating that you did not agree with that timeline. Do you believe that there's been a false narrative of how quickly we ended up contacting, or the president did, in this matter?
It's not that there was a conflict of speed. It seems like there were approvals or endorsements given by the HOA. That might have been by the president or by the HOA writ large, that took place prior to the initial approval of the permit. That included statements that the CEO would have reasonably accepted as statements of fact. And
Okay, and what,
and subsequent to that, those statements were rescinded by the HOA president, but they happened after the permit had already been initially approved. And my point was that the CEO can't anticipate future future statements that contradict or pull back on statements made by the HOA president initially.
and what is your understanding or your facts on the timeline of how that happened, where you didn't agree with it?
I'd refer to the minutes of the meeting.
Refer to the notes in the meeting of the timeline
Well, I'd
of,
refer to the minutes of this meeting where they were laid out by both the CEO and your president.
okay, and I apologize, I thought I heard you state that you didn't agree with them before those facts were.
No, but
laid
you
out.
asked me what did I view as not agreeing. I would refer to the minutes as offered and saying I disagreed with, they were not consistent with a timeline that was capable of being consistent.
Okay. Yeah, so that pretty much ends it for me, other than I would like in our position, as far as, well, I can't speak for my husband, but I'll speak for myself. You know, there were statements, you know, basically that was stated that we are angry, that we're calling code enforcement officers incompetent. And I find that not okay. I don't think you will see that in any of our correspondence, anything that we are trying to put out today. Those are some pretty judgmental things to state, but that is definitely nothing that I have heard or witnessed in this. Also, I would like to know the owners that represented themselves and made the comments that they made as far as the conversations that they had with our president previous. If you see everything that is in writing or the emails that have been forwarded to us, and I go by what was in writing between what was represented to us and shared with us from them. And at no point in time did I perceive any of the emails and things that were forwarded, including some of us who individually received emails from them when the president and the vice president did not. Never did it state that it was going to be a second home that was actually larger than the one that is already standing there. So definitely, if there were verbal conversations that we were not aware of, we have been aware of what was in the emails from day one, and including the personal ones that were sent to individuals that were not in authority as far as our president and our vice president, that I perceived as not an entire huge home. But thank you for your time on this.
Thank you very much for your comments. Is there anybody else who would like to speak on this issue? I don't believe there's anybody online. No, okay. So seeing nobody come, I'm going to close the public hearing. And now what we'll do is, among ourselves, deliberate on the facts that we have before us. Okay. Anybody want to start us off?
Richard,
Peter, you want to start?
first of all, I just want to make a quick comment to kick things off and apologize. My dog just saw a squirrel. What I'd say is that administrative appeals don't have the same list of requirements that we normally see for, say, a reduction in yard use. So if you want to, Richard, maybe set out how we should discuss this or how you'd like to do that, that might be helpful.
Okay, I'll be happy to do that, Peter. It seems to me that we have two issues to address. The first issue is the scope of our authority. And in subservient to that is the scope of the code enforcement officer's authority. We have heard from legal counsel with respect to the code enforcement officer that the gentleman has no authority at all to interpret private agreements, that the limit of in his scope of review and authority is restricted to town ordinances, zoning requirements, and other town documents. You can sort of see how that makes some sense. I mean, he's not an attorney, he's not equipped to do those kinds of things, and there are other venues available for people to enforce documents like homeowners association agreements that are available to the parties to pursue. I can appreciate the confusion, especially with respect to the email that the code enforcement officer sent. People try to be accommodating in all sorts of circumstances, and we see this quite often. A lot of things that come before us ultimately are the result of disputes between neighbors or among friends, and sometimes they can get fairly heated. People in the town understand that and want to avoid those situations. And so wherever possible, we encourage, and in fact, we have on occasion actually tabled appeals to us or petitions to us to try to let the parties work things out. And I think it's natural for the code enforcement officer to do the same. When confronted with a situation where there's disagreement, initially it was fairly clear, it was unanimous. Subsequently, there was disagreement. The scope of the disagreement was presented. And I think like any normal person at that point, the code enforcement officer said, see if you can work things out. If you can, it's good for everybody. Maybe we can get a win-win out of this, maybe not. When it became clear that that wasn't going to happen, the code enforcement officer reverted to what was in his authority. His authority being to review the town's zoning ordinances and determine whether or not the project met the criteria of the zoning ordinance. He found it did, and therefore he issued the permit. Okay. Now you're asking us to step in and say that he made a mistake, that he shouldn't have done that. And you're saying that he made a mistake because the original application was for an ADU, or it should have been for an ADU. The original application was for something that was much smaller than a guest house, even though that term is not defined. And for us to make that kind of a finding, we have to do exactly what the attorney said the code enforcement officer was not allowed to do, which is to interpret your document. is we have to step in and look at the document and say, the single-family home is good, an accessory dwelling is approvable, but what's an accessory dwelling? Is a shed an accessory dwelling? Sure. Is a 5-story office building an accessory dwelling? No, right? But there's something in between there, right? And we're just not in a position to do that, in my opinion. I mean, others may disagree on the board, but in my opinion, that's not our job. We're not in a position to do that. I mean, our job is to enforce Scarborough zoning ordinances and consistent with the way the code enforcement officer has done it. If we thought there was a mistake in what the code enforcement officer did, if he said that there was, there weren't 100 feet of frontage and you actually had 100 feet or vice versa, a factual issue that we could take a look at and it was fairly clear, we would certainly overturn a code enforcement officer on those criteria. But in this instance, I just don't see any. I know you don't want to go to court. I know it's expensive. I know it's not a pleasant experience, but ultimately that may be the only jurisdiction that you have available to you. And the court will be in a position then to determine whether or not what is being proposed is an accessory dwelling unit or not. And that's going to be a finding that's going to be a tricky one, right? It's not clear, but you're going to have to rely upon what the court's decision ultimately is on that. So that's my sense of this and, where I stand on it now. Joe, Shelley, do you have any other opinions or anything else you would like to add?
Well, I think that was very well said. However, I am looking at this letter that the president sent, and he does say very clearly to the code enforcement officer that this can, according to the HOA, it can't be subdivided. It's they can only have one single family on there. It's actually pretty clear, and I actually don't think that the permit should have been issued. I don't think that I think that this letter of approval is very clearly for a guest house or an accessory dwelling. And, the code enforcement officer with that email that he sent rescinding the permit said, oh, I don't know. Let's take a pause on this.
Mhm.
And then he came back and said, well, we're going to do it anyways. Or maybe, I'm sorry, that's an interpretation. I don't think that he should have issued it based on this letter right here. If you guys want to take another look at it, I don't know if you did, but
Shelley,
mean,
my understanding is the timing of that letter was after the initial,
okay.
and that's my timing issue.
I see, my understanding was that's the letter that's included in the, before the permit was issued. There is no date on it.
Yeah, and so this is where.
If I could just interject,
Yeah.
my name is
Please.
Autumn Spear. I'm the planning director for the town and I'm the supervisor for the code enforcement officers.
Yeah.
So that letter, there is no date on it, but that letter did come in while Mike was performing the review with Ryan.
The initial review.
The initial, right. I will say that what I think the events occurred is we thought we were good shape to issue the permit based on the letter and the fact that reviewing the plans is a pretty strong statement. So then when we found out that they hadn't actually reviewed the plans and there were concerns, I asked Mike, we had conversations and we said, let's rescind this. Let's put this on hold and see if we can't get these parties to work together. Everybody had seemed to really be positive and wanting to figure this out. That week occurred, that was not going to happen. So then it became, just as you said, Mr. Silkman, a very black and white issue. We are only liable to enforce our zoning ordinance. This application for a single family home meets our zoning ordinance. In the RF district, they could have 4 single family homes on that 10-acre parcel with 850 feet of frontage. And that's what we're obligated to enforce. And so that's when we issued the permit. We knew that we weren't going to be able to help the people get along. For some reason, rescinding the permit and having conversations really seems to have upset the neighbors even more so. As I have received that information that I was part of that. And I think from a town perspective,
the hopes that we had in that action was to really create a situation where they could work this out. But we also told them, when we do this, this is going to be a civil matter. This is out of our hands. This is not something the town has a role in. So I just wanted to put that out there.
No, thank you very much.
And make it a little clearer. It's in the memo, but I just wanted to be able to say that.
And Autumn, I saw that. I just want to be very clear on the timing because this speaks to actually one of the public comments that was made, and I about my understanding of this, and I should take that personally. I'm glad she brought it up to me personally. It was the right thing to do. My understanding was that the initial approval took place with the understanding that the HOA president had taken a look at the plans and said they were okay. Is that correct?
Correct.
So subsequent to that, so approval has been issued. Now there comes back saying, oh, wait a second. They're not in approval. This really is not an approval with our HOA. That's subsequent to the initial approval, right?
Correct.
Okay. That's my understanding of the timing as well. So, and for the public person who came in, that's my layering of timing. And I think the timing is important for understanding how this plays out. And with that, Richard, I'll send it back to you. I just wanted to clarify that.
Thank you.
Peter, the problem I have with that, sorry, I
Good,
just cut you
good,
off.
okay.
Is that right after that sentence, it so clearly says what their HOA would approve. And so my next thought is, and I don't do your job, I don't know, but I would think that you would need to do a little bit more digging, which it almost seems like you didn't.
What's the date of that letter?
There's no
Do we have
date on it,
time
but she
for that?
confirmed that it came in the
Was it
initial.
before or after the original?
It just seems like there should have been a little bit more questions
Yeah.
asked about this approval.
Well, and Joe, though, Autumn also said that in that letter we've taken a look at the plans, which would seem to supersede anything they said about whether it would
Fair.
fit HOA or whatever. It's like, okay, we've looked at the plans and we're saying okay.
It says as described.
Yeah.
No. Public hearing's over. I know it's frustrating sometimes, but this is how it has to work. Thank you.
I think in all of the conversations, I think that became really apparent for Mike and I, that there were maybe some miscommunication and some other things that we were really not party of, and we had no control or business for that matter regulating. And I think we had conversations internally about, we don't define a guest house. The primary house that's there now could be a guest house to the new guest house for our purposes. We have very large guest houses all over Scarborough. And so we were like, we can't interpret that. We don't have anything to fall back on. And so we really, really did see, after all of the conversations that we had, I personally reached out to several people. I talked to people, Mike had talked to people. We just had to hardline, our zoning ordinance is this, and this is what we are.
I mean, there's a separate line in here that says it can't be subdivided and you approved it to be subdivided.
But we did not approve it to be subdivided.
It's not a separate lot.
It's not a separate lot.
That is
And the fact of the matter,
thing on my part.
the HOA could say things like the height of the grass, and they can say the color of the building. And we could certainly do our due diligence and try to reach out and get them to that. But at the end of the day, when we consulted with our attorney and we had other conversations internally, we cannot regulate based on that. We can definitely tell you that we think you're going to probably have to go to court with your HOA, but we can't prevent that from happening through our issuance of the permit.
Joe, do you have anything to
Yeah,
add?
just briefly on that. Yeah, I mean, there's obviously a lot of emotion around this, right? It affects the neighborhood, it affects neighbors. I mean, it stinks. But at the end of the day, I think the question for me is really, is the town obligated to make sure that an individual that signs a contract, which in this case is an HOA, a set of documents, you're going to do this and not do that, if you're a member of the HOA, is it up to the town to make sure that an agreement, a document, a contract signed by an individual that everything that the town is responsible for making sure that they live up to what's within the corners of that document. And based on everything I've heard tonight, I think the town has even gone an extra step with the rescinding of the original. The moment, it seems to me, the moment the town said, hey, we got an issue with people that are upset that we issued this, let's time out. We don't want the lot owner to spend a bunch of money that maybe they're not going to be able to finish this project, and we're not going to let them march forward until we at least hear what the HOA has to say. And at the end of all of that, after consulting with attorneys and management within the town, and then relying on what's within the corners of the documents that we can act on, which is the code, and the process we use to assess whether a permit can be issued, that we followed all of that. And in spite of all of that, we end up here with people who are upset and some challenges still for that neighborhood, regardless of our decision today. So for me, we're being asked to overturn a decision that's been made by a representative of the town. And I think based on what I've seen and heard, the town has lived up to its obligation and maybe even tried to go a little step beyond that.
Peter, do you have anything you want to add before I ask for a motion?
Yeah, I do. First off, I appreciate the comments from all of my colleagues, and where I kind of shake out on this one is it might sound a little odd. I think the town did everything correctly, and given the sequence of events and the sequence, admittedly with some emails that we might not exactly know the timestamps on, in approving the initial application, the town did exactly what it was supposed to do. It did not interpret an HOA agreement that it does not have the authority to interpret, and it approved a dwelling, whether it's a single-family dwelling or a guest house, which is, and the fact that a Google search brings you to an ADU application is neither here nor there. I trust Google's algorithms about as much as I trust my son's explanation of what he does on Saturday nights. I think the town did everything right leading up to that initial application approval, based on the information it had and based on the assurances that it relied upon from the HOA president, and whether they were accurate or not, they were representations made by the property owner. I think Mr. McFarland made a very important reveal on the email sent by the code enforcement officer on the rescission. However, the rescission unfortunately implied that the town was attempting to interpret the validity of the HOA's subsequent response. And I think that probably was a foot fault. I think that set up an expectation on the part of the HOA that might have been incorrect legally, but nevertheless was set up by town personnel. And I worry about that. In then returning to a final approval of the thing of the project, that final approval, I think, now potentially becomes tainted by that interim rescission step, and not just the rescission, but the rescission with an implication that the town was seeing interpretive evidence that could go one way or the other. And had they decided to rescind the application saying there's a disagreement among the parties, we take no view, and we have no authority to take a view in a civil matter. However, because we are within our 30-day window, we rescind the approval, full stop, period, end of story, we would have a much easier story here tonight. Unfortunately, the town's reply, as quoted by Mr. McFarland, went a bit farther than that. So I'm worried that I think we've stepped over the footfault line and we probably do have a valid administrative appeal here. Maybe not for the reasons that anybody here expects, but that's kind of where I'm coming down.
That was well said, Peter, and I agree with you.
Okay. Anything else? Might as well move this one along. We got to make a vote at some point. What I need is a motion to approve the appeal. Once the appeal is then before us, we will vote yes or no, accepting the appeal or denying it. So even though the motion says approval, it doesn't mean you get your approval. I just want to make that clear. So can I have a motion to approve the appeal?
Motion to approve the appeal.
Second?
Second.
Thank you, Peter. Okay. We've had a lot of discussion about this. I don't think it's necessary to have any more that's in front of us. If anybody has anything that they would like to say, Peter, Joe, Michelle, we're good.
No, just Richard, what is the quorum tonight? Is it a 4-person quorum?
Yes.
So Doreen, if it's a tie, what is the outcome?
Does it need to be tabled? I'm not remembering the exact.
If there's a
policy.
tie, the motion fails.
It fails, thank you.
Okay.
Sorry, say that again. I just
If it's a tie, Peter, the motion fails.
got it.
It-
Okay.
It has to be approved by a majority of those present and voting.
Okay, got it.
Doreen, could you call the roll?
Richard Silkman,
No.
Joe Doherty,
No.
Michelle Stevenson,
Yes.
and Peter Freilinger.
Yes.
Well, 2-2, you saw that coming by virtue of our discussions earlier, so the appeal fails. Thank you all very much for being here. I really do appreciate the civility with which this hearing was conducted. You guys have done a nice job, and you'll be good neighbors for a long time, I'm sure. Thank you.
Thank you very much.
Thanks.
The people that were next are next.
I sat out.
Wait, how's you feel? You gonna do that, Brian?
I have an appeal.
Keep going, you're all set.
Almost 2.
All right, we can do it. The next one's. Okay, I'd like to continue on with the hearing. Thank you all very much for your patience. You could see this was a tough one. People had to have their says, and we need to have that time. The next item on our agenda is appeal number 2798. It's a special exception appeal for a home occupation located at 33 CV Landing Road by Olivia Nardell. By the way, we expected baked goods to be delivered here.
Well, my husband is currently had to leave because he's a sourdough starter, so can't bake him now. We're a micro bakery. We operate off of our landlord's property. We also live in the same place that we operate out of. It is a really small 600 square foot apartment. 400 square feet of that is now kitchen. And we produce solely for farmers markets. We do not have any people coming for pickup or increased traffic.
Mr.
And
Chairman?
what?
Mr. Chairman, if I could ask a question of Richard real quick.
Sure, yes, go ahead, Peter.
Richard, I live around the corner from the appellant and literally walk by her home 5 or 7 times a week. And I worry that maybe that puts me too close, and that
in Scarborough, unless
Make
you're
an impartial decision, do you
in
think?
Scarborough, unless you're a husband, you can vote.
Okay, got it.
I mean, it's a small town. We all have conflicts, I mean, it's, everything down on Pine Point is a neighbor and you just have to deal with it. So
I was gonna say,
unless
I
you
guarantee-
feel
I-
like, you can't vote for some reason.
No, I don't. I just feel like my dog has roamed her property so many times. She's now a resident. So yeah, I just want to say I live very close to you. I see you on a regular basis, and I just want to maybe state that for the record.
Okay, thank you, Peter, but I don't think that disqualifies you.
Okay.
As long as we don't cause any problems for you. Yeah, no, we're a really small operation. We only produce, we only actually bake 2 days a week. The rest is just like mixing doughs and laminating croissants. It's a pretty small, humble operation. We, like I said, we solely do farmers markets. We do not have any wholesale or any retail in-home pickup or anything like that. We don't do porch pickup. We only use the space as a means of production and living. We do participate in the farmers market directly outside during the summer. But it is, like I said, it's a really limited occupation. We do not have large delivery trucks or anything coming into the neighborhood. The largest delivery vehicle is the size of an Amazon truck, which comes down our road daily anyway, besides us. So, yeah.
Okay, thank you. What we need to do
Mhm.
is go through all of the criteria that you have to meet.
Yes.
And so what I would ask you to do is either you can reference your application if you would like.
Yes.
And either read it into the record or just respond to each of the items that we have to find you satisfy.
All right.
Okay? So the first item is that the proposed use will not create unsanitary or unhealthful conditions by reason of sewage disposal, emissions to the air or water, or other aspects of its design or operation.
No, not any more than a regular household would, cooking during the week.
The second item is that the proposed use will not create unsafe vehicular or pedestrian traffic conditions when added to existing and foreseeable traffic in its vicinity.
Nope, as stated, we have no people coming in to pick up goods, and we have one delivery once a week, and it is a small van.
The third is the proposed use will not create public safety problems, which would be substantially different from those created by existing uses in the neighborhood, or require a substantially greater degree in municipal fire or police protection than existing uses in the neighborhood.
I do not believe so. We use a standard oven and range for cooking, so we are not implementing any extra, I would say, precautionary measures.
The proposed use will not result in sedimentation or erosion or have an adverse effect on water supplies.
Not in my books, no. I don't know, no.
The proposed use will be compatible with existing uses in the neighborhood with respect to physical size, visual impact, intensity of use, proximity to other structures, and density of development.
Yes, we are not changing the structure at all.
I don't believe this is located in the shoreline zone, that's correct? Okay, so we don't need F is satisfied. Item G is the applicant has sufficient right, title, or interest in the site of the proposed use to be able to carry out the proposed use.
We reside and live there, and we have full approval from our landlords.
The applicant has the technical and financial ability to meet the standards of this section and to comply with any conditions imposed by the Board of Appeals pursuant to subsection 5 of this section.
I'm pretty sure, yes.
You've been doing this for a while, haven't you?
Yes. Although we did receive a scam email requesting $4,800 for this meeting today.
Auburn,
So-
did you send that?
No, please do not make wire transfer payments.
Not going to.
Anyone.
Nope, not planning on it.
Thank
Thank you.
They're quick.
And the last one is the proposed use will be compatible with existing uses in the neighborhood with respect to the generation of noise and hours of operation.
Yes.
Board have any questions of the applicant? Peter, do you have any questions?
Richard, no, I don't, but I would flag for Autumn that this is one of the micro uses that we've talked about for some of the zoning conversations we've had in LRPC, that
Okay.
this should be some sort of an expedited process. And with
I
that,
just have
Richard,
one.
Richard,
okay, I
Richard,
just
I
have
might,
one-
I
Go
might,
ahead, Peter.
yeah, I might suggest that we, rather than going through each one of these individually, we just have an up or down vote on this one.
I'm with you on
I
that.
like
That's a
that
good
too.
idea. Just one question. You said that you're never going to do retail.
Correct.
Is there any foreseeable circumstance in which you might put a sign up and said baked goods for sale? Like, like you see lobsters for sale occasionally.
No, it doesn't work for us, making it worth it for us to produce. Croissants and sourdough are quite time consuming and labor intensive, and we need to ensure that we will receive those sales, and living on CB's Landing is a really big honor basically that we have, and we don't really foresee ever having people make a trip down CB's Landing. I don't know.
Well, you apparently have a lot of foot traffic.
Yeah, I was gonna say the Fryer family will be.
We're just not looking for it. We recently had a child, and our landlords have 2 young children. We don't want any more increased traffic there.
By the way, your child is lovely too. We love seeing her. So
Sometimes.
Okay, what I'd like to do is open this now to public hearing. If anybody here is here to speak on this particular application. Nobody's online, seeing nobody, I will close the public hearing. Thank you very much for your presentation. Peter, I'm going to take you up on your idea. Could I have a motion to approve?
Richard,
Could I have a motion to find, or that the board finds that all of the standards have been met, and that the approval,
I think including performance.
yeah, including the performance standards, yes, thank you, they've been met, and that the application should be approved.
Motion to approve.
second,
As said by Richard.
Okay. Okay, seconded. Any further discussion? Doreen, could you call the roll?
Richard Silkman,
Yes.
Joe Doherty,
Yes.
Michelle Stevenson.
Yes.
And Peter Freiberger.
yes.
Okay, we're good, thank you. The next item on the agenda is a shoreland setback determination to the greatest practical extent by Custom Concepts. I don't see a number on this one, but,
Shoreland setback determinations don't have an appeal.
okay,
number,
there you go,
so
that's the
validity. Mhm.
Thank you very much. So
Mike, I thought you were part of that HOA because I saw you here. I thought you were part of that HOA when you were.
There. Awesome, thank you. Good evening, Mike Richmond, Custom Concepts.
Actually, Mike, I can't hear you.
Mike,
Peter?
you might need to get closer to the mic or at the podium.
Peter, is that better?
That's much better. Thank you, Mike.
Thank you. So Mike Richmond, Custom Concepts. I'm here on behalf of my clients, John and Sue Ann Carrero, crowd, 43 Clay Pits Road. I will try to be brief after you folks just went through. The Carrero family plans to sell and move from their current home, also in Scarborough, and create a year-round home for their family. This parcel is located towards the westerly side of Clay Pits Road and faces the river. The site contains an existing cottage, a couple sheds, and the site is relatively flat. About 2/3 of this existing cottage lies within the 75-foot setback to the high water line. And the majority of this existing structure does not comply with current setback standards. What we would like to do is raise the cottage up almost 7 feet and install a new concrete pier system to comply with the new floodplain regulations. Remove one of the sheds from the property. Add on to the existing cottage, but only above the existing cottage, directly above, but no taller than the existing peak of the home. Reconstruct a new deck in the exact same location as the current deck, just higher up, so you can get to this house once it's elevated. And construct new stairs to get up to that height. At length, we discussed possibly moving this structure to be more in compliant to the town standards. But the idea of relocating the structure ran into some issues. Most importantly, Department of Environmental Protection typically does not encourage or even issue permits for structures to be shifted closer to the natural resource, in this case, the river. So in this particular situation, moving the structure to be more in compliance with Scarborough zoning ordinance puts us closer to the resource. Plus, the area behind and next to this cottage, it's stable, it's vegetated, it's been that way for a long time. If we did have to move this structure on a pretty small lot, the logistics of installing this new foundation system, overlapping the footprint with the new structure, would involve temporarily moving the structure somewhere else on the property or even off the property. We create a logistical challenge, but worse off, it would disturb most of this site right up against the river. However, lifting directly up and placing it back down exactly where it is, just higher up, would absolutely minimize the disruption to the site. With these limitations, we're proposing that we raise the structure up in its current location and set it right back down where it is, just at a height that meets the standards. With that, I'll answer any questions.
Thank you very much, Mike. Does any member of the board have any questions? Peter, do you have any questions?
Mike, I have a quick one. What is the septic or the sewage situation for this home? And this is entirely
Sewage
curiosity.
situation.
This is not related to the shoreline issue. It's just we've seen a number of these shoreline determination ones with a variety of different wastewater solutions. So I'm just kind of curious.
Yeah, I believe this is on public sewer, so hopefully not an issue.
Yeah, okay, got it. We've seen ones that have more composting for waste disposal. We've seen ones with again this section of the tidal lands of this side of town and Winnick's Neck have had a lot of traffic before our board. So I'm more curious. I think the solution is quite clever and I have no other issues.
Thank you.
Does the raising of the home bring it into compliance with the new flood map?
It does,
Okay.
correct.
It sounds like you've considered several options, and I appreciate you telling us the things that you considered. I don't have any questions, so it's just a comment.
Yeah. And Michelle,
Mike,
I agree with that. We don't have to have options considered for this one, but I appreciate, Mike, that you guys have looked at different things. And again, I think this is quite clever.
You said that there were 2 sheds but for some reason I thought in the diagrams I looked at both sheds were being removed. Maybe I misread it.
So good question. So there are 2 sheds. One is planned to be removed. The other one's actually in decent shape. And I have the lot coverage calculations completed that works with that 1 shed remaining,
For the one remaining?
but not 2.
Mhm.
Yes. I can show you those calcs if you.
No,
want to see
that's fine. If
Okay.
you've done it, I'm sure the code people have looked at it.
They
so.
will.
Just one other question. Are there limitations with the expansion of, are there limitations in the code? You can only expand the property a certain amount?
There are some limitations which are covered in the building plans. The limitation that would apply in this case is that within any structure within or partially within the 75-foot setback from the resource, I believe can only expand to 30% of the original footprint. And that standard has been met in this
Okay,
case.
thank you.
And Helen, there's no issue here that it was built before 1991 or anything like this. This is, the shoreline doesn't have that sort of timeline associated with it, right?
That's correct.
Yeah, okay.
Any other questions of Mike while he's standing up there? I think we're all done, Mike. What I'll do now is open the meeting to any public comments. Seeing none here, nobody's online, we'll close the public meeting session and discuss this among ourselves. Anybody have any comments or concerns about the project?
No, I think, I just say that I think these are the types of projects that the town's going to be seeing more and more of as people look to raise houses within a floodplain. And yeah, I mean, I think the solution they've arrived at, it seems like a good solution. And yeah, the couple of areas I had questions on, apparently they're meeting or exceeding those. So no questions beyond that.
I agree with Joe. I mean, I think that raising it up and not disturbing any more land, this being in the shoreline zone, and with looking into the future, I mean, if they don't do this now, they're gonna be looking to do it at some point, someone's lifetime at least. And so I mean, I think this is the smart thing to do, and I think it's the most conservative option that you can do with this lot.
It is true that they did look, and this does seem to satisfy to the greatest practical extent possible. And I think that's the standard that we have to meet. And so, Peter, do you have any comments?
No, I mean, I agree with Michelle. We're going to see a lot more of these. And actually, Michelle and Joe, we're going to see a lot more of these. I wonder how survivable these really are in 100-year lifespan or 100-year or the rest. But in terms of meeting what we know today, I think Custom Concepts is doing something pretty interesting and something pretty. They've thought about it well, so I'm comfortable with this.
Yeah, I think the owner's here. He's not worried about 100 years. Okay. Doreen, I think we can call a roll call on this one.
Actually, Richard, I will move to approve.
Oh, thank you very much. You're right. We have to move.
A second.
Thank you, Joe.
I would like the record to show you don't look a day over 40. Yeah, are we gonna do an up and down?
Yes,
well?
I think all we have to do on this one is simply a yes.
I didn't mean to sideline.
So, Doreen?
Richard Silkman,
Yes.
Joe Doherty,
Yes.
Michelle Stevenson.
Yes.
And Peter Flyerman.
Yes.
Okay. Approved. They're good.
And for the record, Mike always brings the best pictures and diagrams.
Actually, I was about ready to say, Mike, I'm disappointed you couldn't show equivalent properties nearby, because that's what we always call you out on. Everything else is great, but no,
It's
this
true.
one is great. So
He was ready. He was ready.
Bye-bye now. Thank you. The last item on the agenda, excuse me, is appeal number 2799, practical difficulty variance appeal by Paul Johnson and Jennifer Allen of 34 Westwood Avenue. Paul and Jennifer, you guys all set?
Hi there. My name is Jennifer Allen, and I am a resident at 34 Westwood Ave. And Paul Johnson is co-owner of the property, and he is here in support. He did not show up at 7 p.m. like the rest of us. We are here proposing to create a second lot at 34 Westwood Ave. Our variance is because there's a private road in part of our 180-foot road frontage.
Hold the mic just a little closer.
So I wanted Paul to do this. Do you want to? Okay. Thank you. Is that better? No, much better. I can actually hear it too. Do I need to start from scratch or just?
No, you can still
Okay.
keep.
Actually, if you could, because I didn't hear the first part either, so I apologize, but if you
That's
could.
okay. My name is Jennifer Allen, and I'm a resident at 34 Westwood Ave, and I'm here with co-owner Paul Johnson. I will add in a few things. We're both longtime residents of Scarborough. I've been in the area of Oak Hill since 1991, and he was born and raised here. So we do enjoy Scarborough. We are here looking to create a second lot on our property at 34 Westwood Ave. Our hangup is there's 180 feet of road frontage, but a portion of that is on private road. And because of the private road, we do not meet the requirements for a second lot. So we are asking for a reduction in road frontage requirement. Okay, that's my intro.
We will need to go through the standards.
Yes.
To support your application, which get them into the record.
Perfect.
And it's a very repetitive, but I'm going to ask you to respond just like the others did. to
Yes, yeah.
state.
And I'll summarize our answers here, just so we don't have to read the whole thing.
The need for a variance is due to the unique circumstances of the property and not to the general conditions of the neighborhood.
Correct. We have, as I mentioned, a 180-foot lot. Originally, as far back as I think 1915 all the way to 1982, it was two separate lots. And in 82, the gentleman who bought the house lot also bought the second one, and he put them on one deed. And that gentleman owned it until just recently. I've actually been a tenant in that property since 2016. Unfortunately, the landlord passed away. We had had discussions of at some point I would buy it from him, but I had been living there as a caretaker of the house from 2016 until his passing. And that is when Paul hopped on board with me to purchase the property. At that point, we started looking into dividing it so that we could eventually build another single-family home. And that's when we realized the road frontage issue.
The second item is the granting of a variance will not produce an undesirable change in the character of the neighborhood and will not have an unreasonably rather detrimental effect on either the use or fair market value of abutting properties.
And we think it'll have no negative effect. It was originally two lots turned into one, as I mentioned, in 1982. All the other, except for right across the street, it was a subdivision at some point. There was a plan in place, and there many of the houses around us and down the street are all single-family home lots of similar size to one of our lots. So it'll stay in character.
The third item is the practical difficulty is not the result of action taken by the applicant or a prior owner.
I say no as well as Paul does. With the, I'll speak for Paul, 180 feet road frontage is what we have because of the private road that we didn't create. I feel like, no, it's nothing that we have done.
To add to that specifically is, if I'm not mistaken, the crux of the original plan, which is the easy plan, was to ask for a simple easement of the owner of the private road. And that was our original intent. When we went into town hall and said, hey, there's a private road here. By the way, there's housing beyond us. So there's a duplex beyond. So you have to travel the private road to get to the existing duplex. And so the easy solution is we'll just get an easement from the current owner of the private road. The staff memo, I think, references this, that would then trigger the hammerhead the hammerhead requirements of a private road, and there is no actual place to fit that hammerhead on the lot that we're referencing. So the practical difficulty is actually, the most recent current relevant practical difficulty is the result of a requirement of a hammerhead of a private road. And I don't know when that private road requirement hammerhead was brought into, actually codified at the town level, but my guess is it was relatively recently. So that's the primary crux of why we can't just have an easement on a private road and go ahead and develop this lot.
You said that this was originally 2 lots.
Yes.
And it was combined into one. Right? And that was an action taken by an owner, presumably.
The 2 lots would have been prior to the time that the frontage requirement was in place.
Correct.
I understand, Autumn.
Well, and also we have a rule in our ordinances that if the same owner owns 2 contiguous lots, they automatically become one. So it's sort of a thing that you wouldn't know you were doing by buying it. We have other situations in town that they thought they had a separate buildable lot, but once they own it in contiguous frontage, it becomes one lot. This one is a really unique one. They came to us to talk about this. They meet all of the requirements, but for that frontage on the road. And if you've been out there, the pavement actually continues to the full width of her property, but the town line is just a bit inside. We actually include that portion in our plow line as well. So I originally went to Public Works to see if there was any plans to actually take that portion of the right of way over. It's a strange section, 40-foot wide access easement that's shared amongst several people. So, and then when we met with our engineer and talked about this private way, it's not enough space to actually meet the requirements to do a private way because you have to extend past the hammerhead requirement for the actual turnaround for the fire apparatus. So it really became apparent that this might be the only way to do it.
So,
And-
so,
Hold on
Go-
one second,
go.
Peter. Go ahead.
so it's the prior owner, it wasn't a result of anything the prior owner did, other than buy the property and then forced into this 2-to-1
That's my
on the
understanding.
deed.
I
Okay,
don't know all the specifics, but that would automatically have happened.
okay, thank you.
Peter, did you want to jump in?
Yeah, there's no relief available for the hammerhead requirement.
No, there's not.
And why is that?
It's a public safety requirement and the private way ordinance was adopted in 2006. And that's how we treat all private ways in town.
It's a Scarborough private way ordinance. It's not
Correct.
the state.
Correct. It's
Got
ours.
it. Okay, got it. Just making sure. Got it.
The 4th item is that no other feasible alternative is available to the applicant except a variance.
I think that was just illustrated, so yes. Yep.
5th item, excuse me, is the granting of a variance will result in bringing the applicant's property more nearly into conformance with surrounding properties.
Yeah, and I think at this point, it's worth noting that by splitting this property, we're actually going to be required to tap into the public wastewater. So right now, the current lot is on sewer. And by splitting this property, septic, will be required to actually connect both of these properties to our public wastewater system. So it actually brings it into more compliance and uniformity to the entire Westwood. Then all of Westwood will be served by public wastewater.
So the sewer line goes down the road and
Yep,
then through
yeah.
the private road
Correct.
all the way to the end?
It won't. It stops right here at, yeah.
The intersection,
Yep.
we're the next house, we're the only house on the public road that doesn't have.
All right, so we just
Yep.
extend it a little further.
Yep, extend it to the current house, the new house, and then possibly to the duplex if we talk to the other owners. Yep,
Which
But-
they,
we don't know.
Sure. The 6th item is the granting of a variance will not have an unreasonably adverse effect on the natural environment.
No. There's with the exception of a shed, there's no other natural features there's no
it's already-
wetlands.
Right,
Yep.
it's already a
Yep.
clear lot, it's open.
7th is the property is not located in the shoreland zone or flood management plain. We're good on that? Okay. The 8th item is the strict application of the dimensional standards of the ordinance to the property for which a variance is sought would both preclude a use of the property which is permitted in the zone in which it is located, and also would result in significant economic injury to the applicant.
So I think the first part of the question's answered. The second part is, I'm personally on this property as a co-signer. As Jen mentioned, she was a tenant in the house. And frankly, financially, it was very difficult to purchase the house for Jen. And she's been in Scarborough for the last 35 years. I've been in Scarborough all my life. This was a way of trying to keep the property and the house with Jen. And I, as her friend, have come in and been involved. So if we don't get this, it will result in probably Jen leaving the house and us putting the house up for sale. So.
All right. Is there anything else you'd like to add, or?
Yeah, the only thing I'd like to add is we did receive a $3,800 bill from the town of Scarborough for the work.
Busy.
That budget problem solved.
I have expressed my concerns, but I do think it's important that the board hear that as well. So.
I was ready to pay it, and he said, why don't you wait? And I'm like, no, I've got to get that wired out right now.
Okay.
Any
What
other-
I'd like to do now, Peter, do you have any other questions before I open public hearing? All right, he's good. What I'd like to do is open the public hearing portion of the meeting. Nobody's here, nobody's online. Anybody? Okay, public hearing is closed. All right. Among ourselves,
Do you want to do the go one through 4?
oh, that's a good idea. You're right. Why don't we do that? Since
This
you
is a
mentioned
more-
it, Peter, do you have the document in front of you? Could you start us off on item 1?
I do. This is the most normal variance we've had tonight. So yeah. Okay, let me get to here. The need for variance is due to the unique circumstances of the property and not due to the general conditions of the neighborhood. I would argue that they have demonstrated this. This is an odd neighborhood. In long range planning, we've talked about neighborhoods that are in RF or rural districts that should never have been in rural districts, and this would definitely fit within that zone. So and even within that zone, it is unusual. They're not on sewer, and they have a number of unusual aspects. So I think this is demonstrated. That the variance or the desire for a variance is due to the circumstances of the property. Other properties in the neighborhood probably would have already been initially subdivided into 2 lots, or would have had other options. So I think they've demonstrated this.
Shelley, would you do number 2? Do you have it there in front of you? If not, I can read it and if you'd like.
Does Michelle have her mic on?
Nope, I didn't. Thank you. The granting of a variance will not produce an undesirable change in the character of the neighborhood and will not have an unreasonably detrimental effect on either the use or fair market value of the abutting properties. I would have liked to see a little bit more of the proposed, not everybody has an architect that can have their, drawings and stuff, but maybe a little bit more of a description. But given that, it doesn't seem like it's going to, you're not asking for a huge change, in my opinion. And then fair market value of abutting properties. I don't really know what the abutting properties look like. I would have liked some information on that. This does not seem to me like it will affect these number 2.
Okay, thank you. Joe, would you like to do number 3?
Sure. The practical difficulty is not the result of action taken by the applicant or prior owner. This was discussed earlier and read into the minutes. Really, this is the result of, we'll call it a 2-for-1 exchange on the deed that took place because of the town's requirements. And also it seems zoning regulations have evolved over time that puts further restrictions on moving the property back to that 2 lots without a variance. So I believe this has been met.
Item 4 is no other feasible alternative is available to the applicant except a variance. We've been through this. It looks like the variance is the only thing. The only other thing would be to have the town take over that road, and you've been down that path, and that's not a feasible option. So it looks like the standard has been met.
Richard, I want to challenge this one a bit, and only in the context of the practical variance standards. And we'll come up with this on C8 as well.
Yes.
Or 8. The simple truth of the matter is that they could develop a second single family home on this lot, on the lot, and manage it as a multifamily lot or a 2-family lot, and not have any material economic impact.
Peter, before you go further on that, we have some shaking of heads in the room. And so I'm thinking that maybe that's not possible. Auburn, do you want to jump in on that?
Peter, they would still have the frontage requirement, no
Okay.
matter. So the frontage is required per unit. They wouldn't have to subdivide. They could build another house if they had frontage, but they still don't have frontage.
Does that address what you were going, where you were going?
Well, no, and I want to ask Autumn a follow-on question on that one. The state is effectively telling us we have to allow, we as a town have to allow alternatives here. So
You're right. So LD 2003, the state said that you can build more than one home on a lot, but they didn't stipulate the other part of it. So when we addressed LD 2003, we said, yes, you can build another home, but the second home or unit essentially has to have the exact same requirements as the first home. With LD 2173, that doesn't go into effect until next July. And we've actually talked about this, that if this doesn't work, then okay, we'll fix it that way. But that doesn't go into effect until next year. But you're right, the state does want more housing, and this is a perfect opportunity for infill housing.
yeah, and that's my question on this one. It's because I would love to grant the variance, but it strikes me under the practical difficulty variance, we can't, because other economic options exist that under C8 or we'll deal with it in the future. We'll have it, but that's what I'm struggling with, and that's the crux of it.
I guess, Peter, those other options do not currently exist. So I think that would be that would be the rationale, and things legislatively cannot actually change until the law is in place. And since the town hasn't amended our ordinances to enable that, what we have today's situation is that there would be no other alternative that I can think of. I've kind of gone around and around on this one, trying to figure out what to use. But
Well, and I hate to say it, but the other alternative is tear down the existing house and build something with 10,000 square feet, which would be worth a lot more and produce an economic benefit. And I hate to say it, that meets the 4 corners of what the state courts have established for not representing a significant economic injury. We'll get to that.
Let's hold off
C8.
on this for a moment, Peter. Let's deal with that when we get to 8, because I can see where you're going with this.
So on C4, I understand where the logic is taking us on this one. I'm not sure I'm wholly in agreement, but I want to acknowledge what's been said and say that I think we've heard good arguments, and we can judge on it as we vote.
Can I clarify something on space and bulk requirements as well?
Sure.
For so this is in the R4 zoning district, and without sewer, the minimum lot area would be 20,000 square feet, and this lot is just over half an acre, so just over 20,000 square feet. The sewer kicks in with sewer, the minimum lot size would be 10,000 square feet, but the lot doesn't currently have sewer. This requirement to connect to sewer would come up with the lot split. in the event that the variance is granted. So I just wanted to make sure that that was clear.
No, and I hear you on that one, and I think in general, we want to encourage connections to sewer. There is an issue though, when we'll get to it on C8, is sequencing and do we have to do it, blah, 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 blah. But anyway, for C4, like I said, I think we've had a good discussion. I'm not convinced that it's met, but I'm also convinced that that there is a pathway to getting there on behalf of the applicant that is not unreasonable. So.
I'm sort of with you on that. We had this issue arise with the properties down on, was it Black Point Road, where the Fish and Wildlife wanted a piece of
Yeah.
it, and there was, and I was concerned that we were setting precedent by subdividing a property without the sufficient frontage, but it was, it was for a public purpose, and it really wasn't that egregious. So this sort of is similar to that, don't you think? I mean, we're subdividing, creating a new house. The state wants housing, Scarborough wants housing. It's not an egregious subdivision.
I do, but to your point, Richard, it's a step further down the slippery slope.
Yeah, it is.
Before it was, wildlife, and frankly, the state coming over to the top and saying, this is a wildlife preservation issue. This is really just, hey, hook people on sewer. It's not quite as compelling as the state saying we've got a clear public policy imperative.
Yeah.
So yeah, this is reasonable. People can disagree on this one.
Sure.
And I think that the arguments have been well laid out. And I don't want to, it's late. I don't want to take too much time.
Can I ask a point of clarification, Peter? So as is, there's an existing home on this lot, and you are saying that they could tear the existing home down and build a new one? And that would, I'm trying to understand. I'm trying to understand. They don't want one home. They want to do two homes.
They
So
want to do two homes, but the state, and this again,
well, they want to keep the existing home. and
Autumn,
build-
this relates more to C8.
Okay.
And when I say there is no feasible alternative available to the applicant except for a variance, that assumes that the desire of the applicant for two homes. Well, and again, I'll fall back on this one. If they want two homes, then they could build an ADU, or they could build a separate single-family home and connect a sewer on the
They
property.
can't build a separate single-family home. They could do an accessory dwelling unit. It would be limited to 750 square feet, and two people could live in it. They cannot build another second family.
If they
single-family
connected to
home.
sewer, could they?
No, they don't. Even if they connected to sewer, they would not have frontage for the second single-family home. That's the problem.
Though I don't think it's really our, for us to determine the feasible options here.
Well, but again, if Autumn,
that doesn't seem that feasible to me, but.
and Autumn, is locating a second home a requirement on an R4 property?
I don't understand that. The
So
applicants.
if we go back to the other things here, not a change in the, have other properties been subdivided? Are we dealing with where we're preventing the subdivision of this property, puts a barrier relative to other properties in the area? I don't see it. Why do we have to allow for the subdivision of this property?
I think what you're suggesting is that they may not have met the practical difficulty standard.
Exactly.
Which is, I mean, the dimension part of it we're good on. That's not an issue. But it's the last part would result in significant economic injury to the applicant. And the question here is whether or not, if we deny it, I mean, have we taken so much of the value of the property away from the applicant that it's significant economic injury, or by imposing this Are we imposing that significant, or by denying the variance, are we imposing significant economic injury on the applicant?
Exactly.
That's the question that you're raising. And let's defer that until we get to the discussion. Is that okay with you?
And
Pete?
that's fine, whether that's C4 or C8, I'm kind of indifferent, but that's, I hate to, that is the crux of the issue for me.
Yeah, okay. Since you've been talking a lot, let's go to number 5. Why don't you start on 5?
The granting the variance will result in bringing the applicant property more nearly into conformance with surrounding properties. I would say this is a toss-up, but other properties in the area do have what I'd say are more conforming 10,000 square foot type sizings, and the original subdivision of this neighborhood was somewhat comical in the way that many of our subdivisions of this era were. So I think they have they demonstrate that this will be more in conformance with surrounding properties for those reasons.
Okay, thank you. Shelley, could you handle number 6?
The granting of a variance will not have an unreasonably adverse effect on the natural environment. It's already a cleared lot, so it's not like we're cutting down trees, and I like that. However, you know, it is going to create some runoff, and but I don't think it's going to be an unreasonable adverse effect on the natural environment. In terms of what you would expect of another dwelling. And they're going to get rid of septic, which I don't have an extensive knowledge on septic, but it seems like it's going to be better for the environment to be on the public wastewater system. So I think that they have met this.
Item 7, it's not on the shoreline, so it's not applicable. Joe, since you've been quiet on number 8, let's hear what you have to say about number 8.
Start us off. The strict application of dimensional standards of the ordinance to the property for which the variance is sought would both preclude a use of the property for which it is permitted in the zone in which it's located, and also would result in significant economic injury to the applicant. Thank you for giving me this one. This one's always challenging. I think, as you could tell from the discussion earlier, it's probably the most restrictive of the, most challenging to meet of the requirements. For me, I have a hard time seeing how this is met. For a lot of the reasons that have already been kind of thrown out. It's being used as a lot that has a single family home on it. No, it's not on public sewer, which it'd be great if it were, but it's being used for the purpose it was intended, right? That it's permitted for. So that's the first part. So it doesn't meet the first part, in my opinion. On the second part, that there'll be significant economic injury. So long as it can continue to be used as a single-family home, I have a hard time understanding how that would create economic injury. Yeah.
Yeah, I think that was well said. I think the difficult part about this is we have to, with the wording of this, it would both preclude the use of the property that it's permitted in the zone where it's located and result in the significant economic injury of the applicant. And then we always go back and forth about a significant economic injury. I think if this is not approved, it's not going to result in either one of those things. So I'm having a hard time with this one, like we always do. This is a hard one to prove. This one's tough.
Yeah.
And Richard and Autumn, I know you asked this as well. This is where I bring you could always just tear down the existing house and build a much bigger one and realize an economic benefit. Nothing about the property as it currently exists, without any variance required, precludes you from generating significant economic benefit. And to me, that makes the requirement of a variance for the property in all circumstances not required. You simply don't need a variance on this property to enjoy economic benefit from it. And the state sets a very high bar for what a practical difficulty is. And I just don't see a practical difficulty on this property.
No, I mean, I think I'm generally in agreement. This is always the hardest one to deal with, especially in situations like this where the property, but for just a few feet
Yep.
would be okay.
Can-
Sure, Autumn, jump in.
Can I ask a question? I'm so sorry. I sent them down this path because when reading our ordinance, there is no number 8 for practical difficulty. And so I need clarification on where that requirement is. I just want to know, because I actually have notes in my book that practical difficulty is medium because there's no financial. So I was just wanting to find out.
Yeah, and Autumn, that's interesting.
Correct.
Our training by the state lists the practical difficulty variance as the single most difficult standard to
No,
meet.
that's actually a variant. A straight variance is hard, a limited reduction is easy, and practical difficulty is medium.
And Autumn is correct. I was just pulling it up as well to refer to it in section 5 of the Board of Appeals. It does end at item 7, so I'm not sure why item 8.
That's really interesting.
But
But item 8 is on all the ones that we've
so many
dealt with
Well,
to
for
date.
practical difficulty or for just
Yeah.
variances? Because that I just had to say it because
That's
I'm
a
like,
real
that's why I told them to do
Right.
this.
But Autumn, if that's the
Always have a hard
case,
time with.
if that's the case, then you're gonna have to go back and look at years of practical difficulty variance
Yep.
appeals, because we've dealt with this item.
Yeah, no, that's why I wanted to.
And we have this same discussion almost every single time. We've denied a ton of these because of that.
Correct.
Economic impact every time is.
Well, that's why the difference between the variance is the one that in the ordinance has. That's why I just want to make sure I'm not missing something.
Yeah,
Maybe
I-
there's something else
Well,
I'm missing. That's
well,
why I wanted to ask the question.
Autumn, if you're missing it, we're all missing it, and we need to have some sort of a or Mr. Chairman, I would propose that if there is a confusion whether this C8 exists, we need to kind of-
Let's not move to table yet, because then we'll have to deal with it right away. So let's just hold off for 1 second.
Okay.
Okay. Well, let's just take a 2-minute break. I mean, we can just hold off and
So
just
just
relax.
so you
for a couple
guys
minutes.
know, you filled out this application and it's got these standards, this 1 through 8. So Autumn is saying that there's no 8, right? So 8, which is what we're talking about, is one of the more difficult things to prove, which is we need to clear that up.
That essentially you can't, if you're not allowed the variance, you wouldn't gain any practical use of the property.
Like you're saying things to us, but I don't think we can respond. So
No,
Yeah, I
well,
know.
we're just letting you know what we're
I'm
talking about.
sort of just killing some time so
Oh,
she can.
sorry.
No, I know.
Yeah.
Okay. I wanted to give you an idea of what was happening. This is not very typical to happen for us. But also just trying to fill some dead airspace and time while we do it. So, no one wants to see me dance, but I could if need be.
Straight variance is the most
I
challenging.
believe that
Which
the
you can't
language,
use a practical difficulty
Autumn.
in.
are you saying B2 for the practical difficulty definition? Because I think that it's not a standard, but it's listed in the definition of practical difficulty. Yeah, Yeah.
Yeah, I'm looking at the statute right now.
We're good. I just wanted to clarify, so the order of the bullets is something that we've discussed at a staff level in the ordinance because it's not always clear. The practical difficulty variance section has a section A and B. So 6A lists items 1 through 7, including ending at the shoreland zone requirement. And then section B has definitions of the dimensional standards as well as practical difficulty. So B2 has a practical difficulty definition, which is the definition that's expressed in criteria 8 in this case. We've used templates for these in a, I'm not sure how this ended up as a criteria number 8. So that is unclear to me as well, but that's where the language is coming from. It's not from nowhere. So I think that at some point, this has been added as a criteria of meeting the definition of practical difficulty. But as you can see in the draft decisions before you, the definitions have been provided directly following item 8. So
Well,
I think
and
those are
in
there for
essence-
reference for the board, but criteria 8 is not listed as a criteria or a condition of practical difficulty per the zoning ordinance.
Helen, I'm looking at the Title 30A, Chapter 187, Planning and Land Use Regulation, Subchapter 3, Land Use Regulation, Zoning Adjustment.
Great.
And the practical difficulty comes up in section 4-C variance from dimensional standards. As used in the subsection, practical difficulty means that the strict application of the ordinance to the property precludes the ability of the petitioner to pursue a use permitted in the zoning district to the property and results in significant economic injury to the petitioner.
Right.
So it's a variance from dimensional standards,
Mm-hmm.
which is I think what we're dealing with here. We're not dealing with a setback variance,
Correct.
or the like, and that's where that comes in. It's there are actually 6, not 7, called out descriptors, but there are the 7th is shoreland, which okay, fair enough, and the 8th is interpreted, I think, from the practical difficulty issue.
Yes.
And
That's the same
Which
as
is part of the performance.
that's
You're good. I will not interrupt anymore today.
No, I mean, it's good that you raised it. 8 is not a standard. The definitions have to have some reference in the standards, and maybe it's item 4 that is no other feasible alternative is available. And you have to look at practical difficulty in evaluating the alternatives.
Exactly, and the if I made the headline or the opener for section 4 or item 4C of subchapter 3, chapter 187, subpart 6A, title 30 of the Municipal Land Act, is that the municipality may adopt an ordinance that permits the board to grant a variance for the dimensional standards of a zoning ordinance when strict application of the ordinance to the petitioner and the petitioner's property would call a practical difficulty and the following conditions are met. And again, would cause a practical difficulty is the phrase that we're dealing with here.
Okay, so the question still is before us. We don't avoid it by eliminating section 8 or
No, it just
standard
falls
8.
back on 4.
Or at the very beginning, the legal basis of the appeal. I read at the very top there, it says, yeah, where this.
It's really part of a performance.
We still have to find the practical difficulty exists, and
Thought
that's,
to be understood.
and that seems to be where we're all having a lot of problems.
Right.
So. Any further comments on this, Peter? Do you have any? I think we have
No, I've
exhausted the discussion, but.
I've done my best to help here, Richard, and I would just say, again, it has always been a tough standard. It is tough, I think, by design, and I go back to 2 sessions of MMA training where they have emphasized that practical difficulty is a very high bar. And in this case, the parcel in question has a lot of options that would not affect a practical difficulty to the applicant if they had to look to other alternatives.
Well, and one other alternative would just be to have somebody else buy it.
Yes, exactly.
And that's not the right answer for you, I appreciate, but the question is, do we overcome that? Any other comments? I'm ready to call for. We will have to move first.
A motion that we move to a vote,
Or
or is that the right
move to accept
verbiage?
Actually,
the variance appeal and then.
Actually,
seconded.
Richard, we should probably find, do we have voted findings of fact for each of the
Yes, we have gone down through all of them. We had stopped at item
We haven't
8, but this has
voted on
been the
them
discussion.
specifically, though. Yeah, we need to do each one, I think, right?
Well, and I think we've done them
Oh.
except for item 8, is my point.
We've gone down. Do we have to vote on each one? We can if you would like. I mean,
We
did
should,
it on
but
the
I feel like we
previous-
had consensus on the other ones. This one is the one where we,
Okay, but then that's fine. Let's go through the findings and
Yep.
I think we can do this by show of hands. We don't have to do roll call on the first part. The first one is the need for a variance is due to the unique circumstances of the property and not to the general conditions of the neighborhood. All those who feel this has been satisfied, signal yes.
yes,
Okay, nobody opposed, so that's good. The granting of a variance will not produce an unreasonable change in the character of the neighborhood and will not have an unreasonably detrimental effect on either the use or fair market value of abutting properties. Has that standard been met?
yes,
Good, okay. The practical difficulty is not the result of action taken by the applicant or a prior owner. Everybody feel that's been met? Yes.
yes,
Okay. Item 4, no other feasible alternative is available to the applicant except a variance. Anybody feel that's been met? Anybody feel it has not been met?
no,
Okay, that's 0 to 4 on that one. The granting of a variance will result in bringing the applicant's property more nearly into conformance with surrounding properties.
yes,
That's been approved, yes. The granting of a variance will not have an unreasonably adverse effect on the natural environment. I think that's all yes.
yep.
And the shoreland zoning, done. I'm not sure we should do 8 because it's not really a standard any longer. And
I think it is, Richard. I would disagree. I think it's been correctly interpreted as a separate standard.
okay, in that case, we'll do 8. The strict application of the dimensional standards of the ordinance, the property for which a variance is sought would both preclude a use of the property which is permitted in the zone in which it is located, and also would result in significant economic injury to the applicant. Anybody believe that's been met?
No,
Everybody believe it has not been met? That's 0 to 4, so that's done. So now we have to vote on the entire application.
so I move
The appeal.
to, I'll move to accept the appeal as written.
Okay, seconded.
I'll second it.
Thank you, Joe. I don't think we need any further discussion on this. All those in favor? All those opposed? Oh, wait a minute, we should do a roll call. I'm sorry. I apologize on that. Doreen, please do the roll.
Richard Silkman,
No.
Joe Doherty,
No.
Michelle Stevenson,
No.
and Peter Freilinger.
No,
Okay, the application is denied. That's the last item of the agenda items. We have any comments from the zoning board?
I think that needs to get cleared up it wouldn't have met, I mean, they still didn't meet number 4, so
Yes.
that wouldn't matter in this case, but that going forward needs to be clear.
I agree.
Yeah.
Can we leave that with you, Auburn, to deal with that one?
Autumn.
I think just my 2 cents, it needs to be cleared up and just for applicants here. The standard, whether it's a separate voting item or it's just part of the standards that need to be met that aren't actually voted on, but are considered as part of the voting items, one way or the other, it's taken into consideration. So yeah, in the end, it doesn't change.
And
It's pretty informal at this point, so sure, if you would like to ask a question. Yeah. Yes.
Could they
It's
step
on
to
the, it's on the
the,
board to make that decision.
could they step to the microphone? I just can't hear it, sorry.
Oh, she asked on who makes the decision as to whether or not there's a significant economic impact on the appellant or the applicant. And I told her it's on the boards to make that call.
And, it's on the applicant to show how it would impact you economically. It's that you could, as much detail as you can put in for those is better for us, because you just say, oh, well, whatever the answer is, it's not, we have what we have to go on. And I mean,
It's important for the appellant to know, though, that
you have filled out an application, so, yeah, I mean, you filled out the application, yeah.
the guidance from the state, though, is that if you can't get the variance, you lose effectively almost all economic use right to the asset. So if you had an asset worth 10,000, without the variance, it's worth 0. And the trouble you have with a parcel where you're trying to subdivide it, the unsubdivided parcel probably has economic use of 100,000, and you can't get rid of that $100,000 use. And this actually is given to us as education by the Maine Municipal Association for how to view things like what you're proposing to us in the light of economic difficulty. So it's a very, very high standard to meet that effectively the lack of a variance eliminates the economic use of a property.
So I think the exercise I'm thinking is, I think we are within our legal rights to just.
You might want to step to the mic just so.
Yeah,
people can hear you.
I can't hear you
Yeah,
guys.
sorry, Peter. I think we're within our legal rights to split the property, right? So it's interesting that we could split the property as shown on this diagram and come before you for the new deeded property. And I would suggest that then all of those are met. And I think this is denied for, let's say, this parcel, but I can legally, within my rights as a resident, create a new parcel with this.
No, because then it would have been an action of the prior.
Right,
owner.
sure,
So
right,
then-
but I could argue that the practical difficulty actually arises from a ordinance that was created, right? Or we've already said I can't even legally put a hammerhead on there, right?
Right.
So I'm just saying the thought exercise, because there's a lot of logic here, right? The thought exercise is, what's interesting is, if you look at the property that we're trying to divide, the property we're trying to build on, I think the thought exercise is, I think the answer is actually change, because then I'm a property owner that's not allowed to build a house on my own property that fits all the other requirements.
You would have failed the number 2.
You would have done an illegal subdivision.
Yeah, right.
Which we
right,
can't prohibit you
right,
from doing, but it would
right,
have been an
right.
illegal lot.
Yeah, no, I'm just saying, like, I think, like the economic injury, right? That's all.
We also said, we always get hung up on it. It's the worst part of
Right.
this application, and it gets frequently denied
Sure.
because.
But I think the economic injury is, we did state I co-signed because she can't afford to live there, right? The spirit of the law in Maine is to keep people in their homes. We're going to economically have to sell the house, and she's going to have to move to North Carolina. That's a pretty severe economic injury. And with all due respect, not everybody in Scarborough can, quote, tear down a property and build a 10,000 square foot. So I would argue that I would caution the board from, when we think of economic activity, there's more people that live in Scarborough than people that might have some sort of budget to do some of the, quote, alternatives, because those alternatives are not alternatives in this town for a lot of people.
You also need to preclude the use
we
of
could go on with this
property.
for a
Yeah,
long
no,
time.
I know, you opened the door. I'm sorry. Yeah.
I'm just
I'm
gonna
sorry.
stop it.
Could I make one?
As you should. I'm sorry.
All right.
Could I make one comment, because I think this is directed towards some of what I said. I'm not disagreeing with you. It's that this is the standard which the state courts have given us as a zoning board, we're a quasi judicial body and we have to kind of observe their precedent. So I'm not disagreeing with you in logic or theory. It's just that we can't make that decision on your behalf because we're bound by what state courts have told us to do in the past.
Okay. Anything else for the good of the order? Motion to adjourn?
Motion to adjourn.
A second.
Okay, I guess we're done.
I apologize for asking that question.
No, you were fine.
It's fascinating.
We're completely okay with it.
Yeah, in a morbid kind of way, it's fascinating.
Peter, thank you very much for joining. We're adjourned now.
Did the best I could. Thanks a lot. Take care.